A recent English court decision has held that the cost of litigation funding can be a recoverable cost in arbitration. Although there are a number of unique circumstances in this case that might make it an outlier, the court's analysis is suggestive. In the right situation, there may be compelling arguments for including litigation funding expenses as a recoverable litigation cost. The case was Esser Oilfield Services Limited versus Norscot Rig Management Limited. There, the claimant and respondent had been parties to an operations management agreement. The arbiter found that Esser was liable for a repudiatory breach of the agreement. In addition, the arbiter found that Esser's conduct in breaching the agreement had involved a deliberate attempt to deprive Norscot of resources that could be used in the arbitration. As a result, Norscot had to seek litigation funding of nearly £650,000 from a third party. If the arbitration succeeded, the third party would receive 3 times the amount advanced, or 35% of the amount recovered. The arbiter's award was $12 million in damages and $2 million in litigation costs. The arbiter determined that the cost of the litigation funding could be included in the recoverable costs. This was pursuant to an arbitration rule that provided for cost shifting for the legal or other costs of the parties. In making this determination, it was important to the arbiter that Norscot had obtained the funding by engaging a broker and making a funding agreement at market rates. In light of Esser's misconduct and the necessity of Norscot's actions, the arbiter found that the litigation funding cost could be included as a legal or other cost. An English court later affirmed the award, including the award of litigation funding costs. Of course, there are many things about the Esser case. The cost shifting was undertaken according to a specific arbitration rule in a legal system that routinely makes the losing party bear the cost of the winner's attorney's fees and other legal costs. Consequently, this kind of cost shifting could be seen as a product of circumstances that are simply not present in the U.S. legal system. But Esser includes an important core principle that could make its way across the ocean intact. This is the idea that when a party is impoverished by its opponent's misconduct, the pursuit of litigation funding can be a necessary aspect of litigation. As such, there can be a convincing argument that litigation funding fees are one of the costs that could be subject to fee shifting even under the traditional American rule. If you need help with litigation funding, call or email me today.